Welcome to Legal AF. I'm Mike Sachs with Court Accountability Action, and today we are talking about the Supreme Court's letting Trump 2.0's transgender service member ban go into effect by a 6-3 vote down the usual ideological lines of the 6 members of the court's right-wing supermajority prevailing for Trump. So let's get into this. There have been 2 courts, one in DC and one in the Pacific Northwest, that has called Trump's executive order and the rules put forward pursuant to that by Pete Hegseth unconstitutional, violating the equal protection of the laws guaranteed in our U.S. Constitution. I want to dig into this case a bit because we remember Trump 1.0 also effectuated a transgender service member ban. And that came after a study, and Secretary of Defense Mattis put his imprimatur on it. And it at least showed a little bit of rigor in why they were doing something that they shouldn't have been doing in the first place. Enough that would let this Supreme Court say, okay, let's pretend what's behind it wasn't really behind it. Animus, wanting to erase transgender people and deny their patriotism and service and duty to this country. Let's just pretend that that's not what's at stake, and let's put forward something here that we think courts could justifiably defer to, because courts in this country, as they should, defer to the decisions of the national security apparatus until and unless the national security apparatus is just acting irrationally. Well, Trump 2.0, after the Biden administration lifted that ban, Trump 2.0 decided to say to Trump 1.0, hold my beer. And early on in this Trump 2.0 administration, Trump came out with an executive order that said, and I'm going to quote from here because it's pretty ridiculous in its language. Okay. Beyond the hormonal and surgical medical interventions involved, adoption of a gender identity inconsistent with an individual's sex conflicts with a soldier's commitment to an honorable, truthful, and disciplined lifestyle, even in one's personal life. A man's assertion that he is a woman and his requirement that others honor this falsehood is not consistent with the humility and selflessness required of a service member. That's what we call in legal parlance dripping with animus. Unconstitutional animus that successive Supreme Courts have said doesn't fly when it comes to making classifications against people by law in this country. Now, except perhaps in the specific context of military affairs, where the executive does get way more deference on stuff that would be struck down in any other context. But this executive order seemed to be daring the Supreme Court to say, yeah, we're going to give you all the animus possible. We're going to load this up dripping with animus. We're not going to even be able to defend it in court that what we're saying is justified by any studies, by any statistics, by anything other than our pure contempt for transgender people and wanting to erase them, no matter the service they've given this country. So that was the bet the Trump administration was making, Trump 2.0, that this Supreme Court would say, yeah, but we trust you, Trump and Hegseth, if Hegseth lasts that long. So then two courts. One judge, a Biden appointee in DC, took the first crack at this executive order, and she made clear that she thought this thing was dripping with animus. Judge Ana Reyes, in very colorful terms, both in her courtroom and then in her written opinions. And she blocked it. And then another judge, Judge Settle, who was a George W. Bush appointee in Washington State, Judge Benjamin Settle, and took senior status actually on January 1st, 2020, which was during Trump's first administration. So he offered to give his seat to Trump to fill. So this guy is not some wild-eyed Biden appointee that one could point at Judge Reyes and say she is. This man was a JAG, a U.S. Army Judge Advocate General for his career when he started out from 73 to 76. This man also said that Trump's transgender service member ban is unconstitutional. Now, when he said it, he didn't get into the animus stuff because there's a whole other thing that this court might actually be looking to get rid of this animus analysis because it's a relic of Justice Kennedy's woolly-headed, squishy dignity type gay rights jurisprudence that helped pave the path towards same-sex marriage. No, Judge Settle pretty much just said back in March 27th of this year that the ban is so irrational that he doesn't even need to do that kind of review. He's pretty much just saying, and I'll read from his opinion, that because the military ban and the Hegseth policy cannot survive the intermediate scrutiny that its discrimination triggers, nor the rational basis review that the government argues for, the court doesn't need to get into anything else. It would fail on this record. They didn't offer anything, the Trump administration. The government's arguments are not persuasive and is not an especially close question on this record. The government's unrelenting reliance on deference to military judgment is unjustified in the absence of any evidence supporting the military's new judgment reflected in the military ban. It's equally considered an unquestionable judgment. That very same military had only the week before permitted active duty plaintiffs and some thousands of others to serve openly. Any evidence that such service over the past 4 years harmed any of the military's inarguably critical aims would be front and center. But there is none. There is none. That's what Judge settled on. Because there was no argument other than defer to Trump and Hegseth on their animus-soaked position to rob people like the plaintiffs in these cases of their places in the military and well-earned places. Now, I want to read quickly the named plaintiff in this case. There are 7 active duty service members who are plaintiffs, transgender plaintiffs, in the case coming from Judge Settle's courtroom, and that is now before the Supreme Court. The Supreme Court is now letting Trump and Hegseth throw out of the military. Hegseth, I apologize. As Judge Settle wrote, each has been serving openly for almost 4 years and some for much longer than that. Commander Emily Hawking Schilling, the named plaintiff in this case, for example, transitioned within the Navy beginning in the fall of 2021 in reliance on the Austin policy. That's the policy from Secretary of Defense Lloyd Austin during the Biden administration. She has been a naval aviator for 19 years. She has flown more than 60 combat missions, including in Iraq and Afghanistan, and was a Navy test pilot. She has 1,750 flight hours in high-performance Navy jets, including the FA-18 Super Hornet, and has earned 3 air medals. She asserts without contradiction that the Navy already spent $20 million training her. There's no claim and no evidence that she is now or ever was a detriment to her unit's cohesion, or to the military's lethality or readiness, or that she is mentally or physically unable to continue her service. There is no claim and no evidence that Schilling herself is dishonest or selfish, or that she lacks humility and integrity. Yet, absent an injunction, she will be promptly discharged solely because she is transgender. And guess what? The Supreme Court has just said that's okay. By an unreasoned, unsigned 6-3 order saying that they can go back into effect pending appeal. Now, the case in D.C. that I was talking about, well, a panel of 2 Republican Trump-appointed judges in the D.C. Circuit also stayed Judge Reyes's order. So that's also on ice while we wait for both the D.C. Circuit and the Ninth Circuit, which will be reviewing the appeal in the case coming from Judge Settle's courtroom. They're going to be handling the appeal and coming out with an opinion. Now, very likely the D.C. Circuit and the Ninth Circuit, given their composition, which is a majority of appointees that don't want to erase transgender people from this country, those courts will likely affirm Judge Settle and Judge Reyes's orders, which means this will head right back to the Supreme Court, which today, in its order, said that Judge Settle's order is stayed pending disposition of the appeal in the Ninth Circuit and the disposition of a petition to the Supreme Court for judgment. So, if the court grants that case, which they could very well do if the petitioners and the plaintiffs rather choose to move forward with the case and risk having the Supreme Court put a very bad precedent on the books that would further erase transgender people in this country. If it gets to the Supreme Court, we could very well see this Supreme Court then saying that they're deferring to the military judgment of President Trump and Secretary of Defense Hegseth again, if he lasts that long in office, and trust that this executive order dripping with animus is okay. SCOTUS will have to tell us all that it doesn't care how devoted and professional and patriotic these unconstitutionally expelled service members are, because Trump and Hegseth, if he lasts till then, deserve our deference. Think about that. These are service members that display their courage, their combat readiness, their duty, their sacrifice to this country. And they're being thrown out of the military because Trump, or whoever wrote this executive order from Project 2025, said that honorable service is overcome by a bare assertion that their life, their existence as a transgender person, which has had no effect on their service to this country, is not consistent with the humility and selflessness required of a service member. So we'll see what the Supreme Court ultimately does if this case does get to them. But for now, what they've done is given this administration, which has been dedicated to hurting people, a free hand not just to hurt more people, but in doing so, hurting our country and our national defense in the process. What you can do watching this is pay attention. Be aware of what's being done in our name by those seeking to secure our country while doing nothing of the like, as we've seen if you read these lawsuits and the plaintiffs who filed suit. They're heroes. And they're being cast aside by nothing more than their identity, by who they are. Not by what they can do, what they've proven they can do, and how they've been trained at considerable cost by this country. So pay attention. Think about this moment, this autocratic moment we're in. And stay up on it all. And hold our elected officials accountable. I'm Mike Sachs with Court Accountability Action. You're watching Legal AF. Subscribe, keep watching, stay with us. Thank you.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.